What's up, everybody? It's Jason Cruz here once again with another episode of Legal Submission. And we have some big news coming out of the UFC antitrust lawsuit. The Judge Boulware, has denied Zuffa's motion for summary judgment in the case, meaning that it is more and more likely that we will be having a trial in April of this year. Now, the order came down Tuesday. Excuse me, the order came down Thursday, and Judge Boulware essentially denied Zuffa's request to dismiss the case as a matter of law. Judge Boulware found that there were disputed issues of material fact that needed to go before the trier of fact. Also, in the ruling, Judge Boulware denied Zuffa's motion to exclude Dr. Hal Singer and Dr. Andrew Zimbalist, which are the plaintiff's key experts. He did indicate that there would be a hearing for Guy Davis because in his class certification order in August, he believed that it was unambiguous as to whether or not he had denied the motion to exclude his particular evidence. Davis, I believe, is the damages expert for the plaintiffs. So what's the big key takeaways here? The Judge Boulware premised his opinion based on what he had already written in the class certification order. He essentially indicated that on behalf of the experts, that he had assessed the experts' testimony and the weight of their particular expert reports according to Evidence Rule 702 and Daubert, basically indicating that it is what Dr. Singer did, Dr. Zimbalist did, were within industry standards, and even though particularly Singer's methodology of accounting might be unique per Zuffa, it is still within the realm of expert testimony and should be included before the trier of fact. Zuffa, on its accord, lost everything in its motion. The motion to summary judgment basically indicating that it had a pro-competitive reason for its business, a business justification for how it ran it, indicating that the contracts that they utilized were similar to the ones that others within the industry used. Of course, Judge Boulware, similar to what he said in the class certification opinion, indicated that there was enough disputed material issues of fact, there was enough evidence for this to go before a trier of fact, to go before a jury. There was enough information to assume, whatever, however you want to phrase it, but there was enough evidence there to dispute whether or not Zuffa's business justifications, business acumen, were anti-competitive and against the rules of antitrust law within the United States. Mainly, the contracts here were of interest. It came up as far as the justifications for having longer-term contracts, 30-month contracts. As Zuffa claims, they needed it because of all the events they were putting on, the investments in these fighters, that they needed to have longer-term contracts. Well, on the other end of that, the Lee plaintiffs showed the fact that it restricted fighter mobility and their ability to get better pay in other promotions. Now, getting paid in other promotions might not be a justifiable fact, but the restrictions on fighter movement and the inability to get out of contracts through different types of clauses, whether it be the champions clause or the right to match clause. Those types of clauses are things that the court had pointed out, or the court had inferred were material issues of fact that must come before a jury to determine whether or not they were anti-competitive or not. A couple of other takeaways from Judge Boulware's order. Zuffa had attempted to make the claim that plaintiffs had originally had its experts do its evaluation of damages for the fighters based upon a monopoly and monopsony study, a monopoly and monopsony claim. And as we know, plaintiffs had taken back its monopoly claim and were going forward with a claim based upon monopsony. Now, Zuffa had made the narrow argument that since the experts were assessing the case based upon monopoly and monopsony, once you take away one, you cannot readily assess you cannot not readily assess a monopsony claim, to which the court summarily denied that particular argument, saying that even if the experts had assessed both, had made conclusions based upon a monopoly and monopsony claim, it didn't really matter. We're going to go ahead and hear the case anyway. It would not halt the case from going forward. It didn't have an issue with respect to standing. Zuffa had claimed that based upon the expert analysis, there should be issues related to Article 3 standing for each class member, and that should be an independent basis for summary judgment. But the court indicated that in Olean, the tuna case, the Ninth Circuit explained that plaintiffs are required to establish the elements necessary to prove standing with the manner and degree of evidence required at the suggested stages of the litigation. So at the time, the plaintiffs were going for both monopoly and monopsony claims. The fact that they had yielded to one, decided not to pursue a monopoly claim, does not make it make the monopsony claims go away, because they had made claims on both, not two independent claims. So long story short, those claims go in. There was also an issue related to the fact that the evidence rules had changed, to which the court was much more of a gatekeeper for the evidence, expert evidence, and whether or not that should go in. The Judge Boulware addresses this by stating that actually the evidence rules that Zuffa had claimed were changed were actually clarifications upon the rule, and the court itself had determined that the expert testimony of the plaintiffs could be admitted before the court. Now, there still is the issue going forward at the time of trial when they introduce the evidence, whether or not that can come in. But that discussion is for another day. So, what does this all mean? It basically means that, from one perspective, this is good news for the plaintiffs. They are not going to be hindered by a motion for summary judgment. Even though Zuffa has a right to appeal this decision, I think it's unlikely that they will. So we do have a trial date set for April 8, 2024. And both parties will have to get ready for that. It also means that Judge Boulware has been pretty liberal with allowing the experts in. I think that there's the case that he does not want to foreclose any of the expert opinion at this particular juncture, rather saving that for a jury to decide and decide on their own the weight of the evidence and the trust factors of that particular evidence. Meaning, it will come down to the jury to determine how much or how little they believe the evidence that will be presented to them at the time of trial. Now, they still do have to introduce these things, the expert testimony and the evidence. It will be allowed, but it will be up to the jury. Now, I think that Judge Boulware did this deliberately because he did not want to stand in the way of this particular case getting its time in court and its ability to provide the information to the triers of fact, meaning the jury. So that's it for now. The motions to exclude, we'll talk a little bit more when the Guy Davis ruling comes down the pike. I doubt that Guy Davis will be excluded. Moreover, Dr. Hal Singer's testimony is more important here, as we will start to discuss more and more as we get closer. Once again, this is Jason Cruz for the Legal Submission. We'll talk to you later. Thank you very much.